Hello everybody. You are about to complete chapter 3, which deals with crucial issues, the classification of armed conflict and the temporal as well as geographical scopes of application of IHL. We will discuss those issues with our guest expert today, Professor Dapo Akande, who is professor at Oxford University. So, dear Professor, we are very happy to welcome you to this MOOC. Many thanks for having accepted that interview. And we have the pleasure to make this interview in a very nice place, the Egmont Palace in Brussels. And the Palace is actually hosting a conference on IHL, in particular a conference on the RCRC new commentaries on the First Geneva Convention. And you just took part in the second panel of that conference and about the classification of armed conflict, the scope of application of IHL, in particular the classification of armed conflicts. This clearly shows that your expertise in the field is well known and well established. So I would like to ask you some questions. Let's start with a very general question about the scope of application. We have seen in the chapter that there are different rationales for arguing for a broad or narrow application of IHL. So what's, in your view, the best approach, especially in light of human rights law?
Well, first of all, let me start by saying that it's a real pleasure to take part in this MOOC. It's a pleasure to be here, also in the surroundings of the Egmont Palace at the Belgian Foreign Ministry. And so thank you for inviting me. In relation to your question about how best to think about the application of IHL, whether a broad application or a narrow application of IHL, it reminds me really of the question as to whether or not IHL should be regarded as a regime which is one of protection. So it's one which protects and has certain prohibitions, or whether IHL is one which should be regarded as one which actually gives permissions. It's a permissive regime. It allows states and other entities to do things which they would not otherwise be entitled to do. That debate about what IHL is really trying to do is a debate which we see reflected actually in the debates about the name of this body of law. So on the one hand, you have some who refer to it as international humanitarian law, like the ICRC always does. And that carries a certain message that this is a body of rules which is humanitarian in nature, and those are its objectives. Then there are others who say, well, really this is the law of armed conflict or the laws of war. And what they're trying to say there is that it's not just humanitarian. They're trying to say it's about balancing two things, only one of which is humanitarian. So it's about the balancing of humanitarian objectives with concepts of military necessity. And within that debate, just about the name of the body of law, you can already see this debate about, is it just about protection, or is it also saying something about what is permitted? So I would like to frame the question with that idea in mind. My view is that we have to view this in a historical lens. So whether we apply IHL broadly or not, we have to view in a historical lens, and we have to view it against the other bodies of law that are applicable in the situation. The example that I like to give is, if somebody says, if you're sitting under a tree and you're shading yourself from the sun, whether that tree is protecting you or shading you from the sun does not just depend on the position of the tree and your position, it also depends on something else, the position of the sun. The tree can be in the same place, you can be in the same place, but at one point in time, the tree is protecting you, and you may find that later on in the day, that tree is not protecting you anymore. So what is the point I'm trying to make? The point I'm trying to make is that it is crucial to view IHL against the background of what else is going on. And so clearly in 1949, when the Geneva Conventions were drafted, IHL was protective and overwhelmingly protective in the sense that it was restricting states from doing things which they would otherwise have the ability to do as a matter of law. So this body of rules was establishing protections against things that they would otherwise be allowed to do. Now, though, the question of what they would otherwise be allowed to do is different. It's a different question now. When you ask, if there was no IHL, what would states be allowed to do? You have to ask that question by reference to other bodies of rules, primarily human rights law. So it's a long answer, but my point essentially is that now my view is that IHL actually has to be seen, and the extent to which we push the application of IHL has to be seen against the background of other bodies of law. In a technical, formal way, my view would be that IHL continues to apply in the way in which it had always, in a sense, applied, but doing something which is in conformity with IHL may nonetheless be a breach of the other obligations. So what my point is that even though IHL may apply in exactly the same way, what you're doing may nonetheless be in violation of human rights obligations, and we have to take that in mind, bear that in mind, even though IHL may be saying the same thing today that it was saying before.
Oh, thanks a lot. So you say that international humanitarian law, the law of armed conflicts, was very protective at the beginning. Do you think that something changed in the future, or do you consider that no, it's less protective? It's more emphasis is put on the allowing, the capacity of permissive aspect.
Yes. Yeah, I think something changed, but it changed not in relation to international humanitarian law, but it changed in relation to the norms that surround international humanitarian law. So now there are some things which states would not be able to do because, for example, human rights law prohibits them from doing these things, which we now have to take into account when we think about the application of IHL. So let's think very concretely. Let's think, for example, about the ability of states to detain people in an armed conflict. The law of international armed conflicts in the 3rd Geneva Convention, the 4th Geneva Convention, allows states to detain, but it also gives some guarantees to the people who are being detained. Now we have a body of rules of human rights law which impose additional restrictions in the sense that there are now things which states would have to do. So if we think, for example, about a state which is detaining somebody on its own territory, even in the context of an international armed conflict, you might say, well, under the Geneva Conventions, you can detain this person indefinitely. You don't have to take them to a court. You can use, an administrative board or something like that. I think now we would have to see that differently in the light of human rights law, which imposes obligations that go further. I mean, maybe human rights law itself also has to change a bit in the light of IHL. I also think that's the case.
There's a contact.
Exactly. But the contact between the two means, I think, that IHL will have to change. Yeah.
Thanks a lot for this answer, and I loved your analogy with the tree, and the person under the tree.